welcome everyone. My name is Ezil, and I'm going to be your host for this event. It's a short 1-hour event. We have 55 minutes left, so we have to speed up a bit. And I'm here today with Hannah Lester and Kerry Rees, and we've been organizing this event together. 3 companies joined forces to pull off this event. So I'm personally from a company called Bright Green Partners. And what we do there is basically helping companies get into alternative proteins and navigate the field. Anything from innovation and technology scouting to helping them guide their strategy, all the way to setting up operations and production facilities. So we really are a one-stop shop when it comes to getting into and navigating in health proteins. So this is on my side. I will introduce Hannah and Kerry and their companies in a second. But really, we realized the past few months that there was an opportunity here when it comes to organizing an event where we look both at regulatory and also at intellectual property and the overlaps of these. We realize that there are a lot of overlaps. There are also lots of differences. And we also realize that many small and also large companies sometimes struggle navigating these 2 areas. And that's a challenge because it is something necessary, especially when you look at alternative proteins. Many of these products count as a novel food, which means that you will need to get it approved. Otherwise, you cannot go to the market. So it is a must. There's no other way. But also at the same time, you could even use it as something, as a differentiator for yourself to stand out from your competition. So then here comes the intellectual property part. And again, there are overlaps, differences. It's hard to navigate. So we thought, let's organize an event where we look into both at the same time and the overlaps and be even more focused on this. So let's look at the data part, because for both processes, you need to generate and provide data. And again, there are overlaps, differences, and it's super important which one you start with, where you apply first, second. And in some ways, we know that it is a science, but it's also an art in some cases. So it's a fine balance. We hope that we can clarify some of those burning questions today. So if you have any questions today, please feel free to ask on the left side at the Q&A section. We will get back to all those at the panel discussion. But without further ado, so I think it's time to dig into our first talk, which will be done by Kerry. On the intellectual property side, and shortly introducing Kerry. Kerry is a biotechnologist, biochemist with many years of experience in intellectual property. He's also one of the partners at HGF, which is one of the leading companies out there when it comes to intellectual property, IP, trademarks, licenses. And I know that Kerry and the rest of HGF team are strongly focusing on alternative proteins, with a mindset of how to help companies use IP as a strategic differentiator, both when it comes to positioning themselves, but also when it comes to attracting more investment. So without further ado, Kerry, I think now is the time for your talk. So please, if you could try to share your screen and go ahead, we're excited to listen to it. And also, unmute yourself because it's muted. So
there we go. Right, can you see my screen?
Yeah, so perhaps if I think it's fine like this, but maybe even better if you could make it full screen, if that's possible, or at least try to magnify it a bit more to like now it's perfect.
Great.
All right.
Let me just I'll get underway then. I just had a slight heart attack thinking that I couldn't share my screen, but that seems to have worked. So I'll kill my camera, and so hopefully you can still see my screen. So you
it's
can
all good, Kerry. We can see it perfectly. So please go ahead.
Great. So good afternoon, everyone. And first, many thanks to Geza for the introduction, and also thanks to Hannah and Geza for inviting me along to speak alongside them today. So my name is Kerry Rees. I'm a partner and a European patent attorney within the life sciences team at HGF. My background is in molecular biology and biochemistry. I've been a patent attorney for around 20 years. And in the last few years, I've been focusing my attentions on the old protein market in food tech. So today, I hope I can share some of my experiences in helping the food tech companies I work with, particularly those in the old protein field, and how we've developed their IP strategies. And as a part of that, what data in particular is required in a patent application for it to stand a chance of being granted before the European Patent Office. But first, before I go into the details of the presentation, I thought, if I may, just provide a little information about HGF. So HGF is a specialist IP law firm. We are one of the largest firms in Europe and the UK, with around 21 offices, 60 partners or so, and around 150 attorneys. We deal with all aspects of intellectual property, including all the IP aspects you see listed here. So I'm a patent attorney, as I said, but we also have trademark and branding attorneys and IP solicitors who help with transactional IP, such as licensing, contracts, and IP litigation. So into the presentation today. So what I plan to discuss today is what is required in terms of information and data to be included in a patent application for all protein-related technology. So I should say from the outset that I'm a European patent attorney. This presentation is from a European perspective and in relation to European practice. And this practice might vary from countries outside Europe. But in any event, so please take that on board when I'm talking about the requirements. This is really European-centric. So in the next 50 minutes or so, I'll give an outline of what products can be protected in the old protein field, what are the requirements for a patent to be granted. And as part of that, we'll see that experimental data is important for a successful patent application. And as a result of that, we'll see that there's a trade-off between filing early and having enough data to support a patent application, and whether it's possible to address objections such as lack of sufficiency and lack of inventive step that might be encountered during the patenting process by relying on data generated after the filing date. So is that allowable? So what can be patented in the old protein field? Well, the good news is that there are no specific provisions that exclude any particular aspect from patentability in the old protein field. So for example, there are some exclusions in patent law in Europe that prevent patenting of things like methods of treatment by therapy or computer code, but there are no such exclusions in the old protein field. There's no particular, it's treated like any other food technology or any chemical. There is a wide variety of technologies that can be protected. So typically, patent applications in this field will have claims directed to things such as the food product itself. These are valuable claims since you want to protect the item that you're actually selling, but also methods of making the food product. That's also quite valuable. If you've discovered a better or a quicker or cheaper way of making a product and you want to stop competitors from carrying out that method. There are other aspects, such as any novel and inventive food ingredients that go into making the final product, enzymes, microorganisms, if it's a synthetic biology approach, or it's a novel yeast and fungus that express proteins, but also apparatus, I should say, and components used in manufacturing processes. So in the cellular agriculture field, for example, the bioreactors, the culture media, the cells that are used, all of these are potentially patentable. So the message is that there's a huge potential for patenting in the old protein space. But as with any technologies, there are certain requirements that still need to be met in order for a patent to be granted. And they are that the product or the process is novel, that it's inventive, so it's not obvious from what's been done previously. But there are additional requirements, so industrially applicable. That's something that shouldn't be a problem for inventions in this space. So industrial application is to prevent patenting inventions for abstract ideas like business methods or computer code. So I don't foresee that might be a problem in this field. And another aspect is sufficiency. So the main use of data is in addressing inventive step and sufficiency. But just to sake of completion, novelty means that the claims which define the patent monopoly in your patent application must not have been disclosed in that combination in the prior art. So that means not disclosed anywhere in the world in any form, so any written or oral disclosures or any disclosures by yourself count against in the assessment of novelty. So there's a strict novelty provisions in Europe. So as I said, the theme of today's presentation is data, and really these features, data features in the assessment of inventive step and sufficiency. And I'm going to go into more details, but first, what do we mean by data in the context of a patent application? So in terms of sufficiency, we're talking about the amount of information contained in the patent application that allows the skilled person, the person skilled in that field, to reproduce the invention. So if the claims are to a food product, then generally the details of how to produce the food product and the experimental data that shows that the product was produced, that needs to be, ideally, it needs to be present in the patent application on filing. So you can't add stuff after filing. It has to be present in the application when it's filed. If the claims are a method of producing a protein from a microorganism, then maybe details of the microorganism will need to be put in the patent application. Maybe a deposit of that microorganism is needed before filing the patent application, so the skilled person has the necessary information at his fingertips in order to reproduce the invention. So, and if you're pursuing claims to, or broader claims, then more examples will be required or more information. So if the claim specifies a temperature range or pH range or a concentration range of reactants or ingredients, then it's useful to have examples and data that support that the invention is achieved at each endpoint of the ranges, and also at a couple of points within the scope of that range. In terms of inventive step, data that is at least plausibly, in terms of plausibility. So I'll come on to plausibility in a minute, but if for inventive step, we need to show ideally that the application solves a problem, and the problem is defined in relation to what are the differences between your invention and the prior art, what technical effect arises as a result of those differences, and then what problem are you solving. I'll discuss that more in the following slides, but basically the data that is needed will ultimately depend on what problem the invention solves, and this is assessed in relation to the differences between the invention and the prior art. In the context of the later presentation from Hannah about the regulatory process, things like toxicity and safety data are not necessarily needed in the patent application, unless, of course, the aim of your invention is to solve some sort of toxicity or safety problem. But such data isn't necessary per se for a patent application to be successful. It really depends what the invention is and what problem you're trying to solve. Comparative data is quite good as well sometimes if you're trying to show an advantage or an improvement in your invention compared to the prior art, and it might be an idea to include that comparative data in the application on filing. But of course, you need to compare and in a fair way. So you need to do the same experiments, the same concentrations, so that proper comparatives can be drawn. So I've explained that data needs to be present in the application on filing, but really the amount of data or the information or the amount of information is such that the invention is plausible from the application documents as filed. So you don't need, for example, the concept of plausibility was developed by the European Patent Office in case law in order to strike a balance between a demand that a patent contains full data. So if you think about, say, I don't know, a pharmaceutical composition, that you don't need clinical data, which is likely to be obtained much later down the line in the development of the drug. You don't need that level of data in a patent application, but also you don't need kind of mere assertions or just a proposal as a technical effect. It needs to be plausible. So there needs to be data and information that the skilled person could would understand that it is plausible from your application documents that the invention is achieved. So the idea of plausibility has an effect on the decisions about when a patent application is filed. And really, it's a balance between filing before a competitor, and therefore before there's a public disclosure is another example, or if there's going to be a launch of the product or discussion of the method or a product in a journal article or in marketing or in publicity, then the patent application needs to be filed before that happens. But there needs to be enough data and information contained in the patent application on filing to make it at least plausible that the invention was achieved. So you don't want to file too early because you don't have sufficient data to make it plausible, but then you don't want to delay too long either because you want to be competitors and you want to minimize the chances of a public disclosure happening, which would be ruinous in terms of novelty. There's an opportunity to add data or more information to the patent application during the first year from filing, the so-called priority year. But after the end of that priority year, no further information can be added. So what could happen by supplementing the application within the priority year is that you end up with a series of dates, all of which have so-called priority dates for a future for a filing. But then in your future filing at the 1 year stage, you file, say, an international application and claim priority back to all of those various dates. But if those dates are not sufficiently supported, there's not enough information on each filing, then potentially that priority date is insufficient and therefore invalid, which could have problems if you assume that your priority date is valid, but then it turns out not to be because there's not enough information. You might have disclosed enough for a novelty destroying disclosure, but not enough to be able to claim priority back. So you really do need to assess what data and information you're including in the priority in an application and whether that is sufficient to meet the plausibility requirements. But what happens at the end of the priority year? Well, after the end of the priority, you can't add any more information into the patent application, but you can rely on post-filing data as a backup. And there is a body, so the next 4 slides are quite complicated, and I'm not going to talk about these in great detail. I think my intention here was to provide lots of information to read afterwards, but it provides a kind of nice summary of the boards of appeal from the European Patent Office on where the current standing is on determining whether something is plausible, and then whether you can rely on post-filing data to back up the claims that you make in your patent application. So, but in summary, there is a body of case law that is developed from the boards of appeal of the European Patent Office, which deals with the concept of plausibility in relation to sufficiency and inventive step. And these are detailed, like I say, in these 4 slides. First, an insufficient patent application generally can't be cured or remedied by adding information after the filing date. The information contained in the patent application must render the invention plausible, like I said. So, for example, it's plausible that a particular food product having particular characteristics is obtainable on the basis of the information contained in the application. And you can supplement that with common general knowledge of the skilled person. But it's clear that a mere assertion as to a technical effect or what an invention does is not good enough to meet the criteria of plausibility or that plausibility threshold. So another way of thinking about what is plausible is that the application need not prove that a product works or has a particular effect, but there must be something for the skilled person to think that there is a reasonable prospect of that happening. And that could be based on the common general knowledge or based on the information contained in the application. You can't add more information to make something plausible. But on the basis that you have attained that plausibility threshold, you can then file post-filing evidence. So evidence you obtained after the filing date, where you can't add it to the application, but you can refer to it in the prosecution before the patent office. Then you can use that kind of data to support an inventive step or to validate that the application is sufficient. And there is a note there, though, that if you rely on common general knowledge to to prove that something was plausible, there is a trap, there's a squeeze trap. So if you're taking inferences from the prior art, that might be useful in establishing the plausibility, but classic inventive step, you still need to show that something isn't obvious. And that might be tricky if you're relying on something that is disclosed in the prior art as a way of establishing plausibility, but then you're trying to argue against that it's not being obvious, an obvious development of what's been done previously. I'm going to move forward quickly through those 4 slides, like I said, but and that's what I just said. If the effect is plausible, then post-published, post-filing data can be used to support inventive step and can be used to validate its sufficiency. But the take-home message is that there's always a judgment call as to whether to file a patent application based on the pressure to file before public disclosure versus having enough data and information in the patent application as filed to meet the plausibility hurdle. But there are some practice points in striking the balance. And this really just summarizes everything I've just said. Plausibility can be applied to inventive step and sufficiency. You need to have enough information in the patent to make it plausible that those 2 things are achieved. If you've met the plausibility threshold, then you can rely on post-filing data. Relying on the prior art and common general knowledge is a risk because that might affect the assessment of obviousness, and you might not be able to show that the invention is not obvious. And you need to weigh up the value of delaying filing a patent application in order to achieve or to obtain the correct amount of data, and the risk that the invention might be filed by a third party might beat you to it, or there's a risk of a public disclosure. And that's it. Me for the time being. There's my contact details. I know there's a question and answer session at the end, but I think we'll leave all questions to that point. But please feel free to contact me after this webinar if there are any questions I can help with.
All right, thanks, Kerry. Thanks a lot. Hope that was great, very insightful, and I hope that everyone in the audience enjoyed your presentation. As said previously, we will have a time for questions at the very end. And now I will try to find Hannah in the audience. Hannah, if you can hear me, then please jump here to the stage.
Hello, yeah, I'm here.
Perfect. I'm here. Yeah, all right. So our next speaker will be Hannah Lester from Pen&Tec. She's the CEO of Pen&Tec Consulting, one of the leading consultancies in regulatory affairs. And Hannah also has a background in science and 15 years of experience with regulatory affairs, and very, very passionate about alternative proteins as well. A crucial part of the alternative protein community. And so Hannah and Pen&Tec is all about supporting companies with their regulatory activities, all the way from initially looking into what needs to be done, setting up the roadmap, and all the way to creating the dossiers and handing it into the approval authorities. But without further ado, I would like to hand it over to you, Hannah, and please take it from here. Hope everything is going good on the tech side. Let me know if you are ready.
Yeah, no, I'm ready. Can you see my screen okay?
So for now, we can only see your background, but
you can't see the actual slides.
So if you could just perhaps try to reshare it and then select the
Let me see if that's working. It was working earlier.
Yeah, we're gonna figure it out in a second, I'm sure. And for everyone in the audience, please feel free to pitch in any questions to the Q&A section on the left side. We're gonna get back to them after Hannah's presentation. Now we can see it, Hannah, but it's a little bit small. So if you could maybe make it full screen, that for sure.
Good. Are we good?
Yes, we are good. Just so you know, we cannot see you, which is all good. But just so you're aware.
Okay.
We will go off stage now with Kerry, and the stage is yours.
Brilliant. Thank you, Geza. So good afternoon, everyone, and thank you for joining us today, and particularly for my talk on data protection for alternative proteins. So today I want to give you a brief overview on data protection and data confidentiality and what the EU regulations say about these very important topics. So to start off, I want to cover today what is data protection, what are the data requirements for a novel food dossier, how does data protection work for novel food applications, and most importantly, which data and studies can you claim data protection for? I want to present some recent precedents, so some recent novel food authorizations that were granted data protection and some that were not. I then want to sort of briefly go over what's the difference between confidentiality and data protection for novel foods, and also very importantly discuss how the new EU regulation on transparency will impact the confidentiality of your data, and then finally just outline what data protection there is for alternative proteins used in animal feed. So what is data protection? So the first thing to note, and it's very important, that all novel food authorizations are generic by default, which means that any other company or food business operator can place the same product on the market as long as they comply with the authorized conditions of use, the authorized specifications, and the labeling requirements. However, applicants can request data protection for newly developed scientific evidence and proprietary data at the time of dossier submission. So how does it work? So basically, in Article 26 of the Novel Food Regulation, this article covers everything to do with data protection. And it basically says that an applicant can request data protection at the time of dossier submission. And what this means is that no other company can benefit from your data for a period of 5 years. But it is important to note that even though you have this data protection, another company can submit their own dossier with their own data for the same product. So the data protection protects your data, but not the product itself. And whether data protection is granted or not is decided by the European Commission. And something else that's important to note is that data protection cannot be claimed for traditional foods, so it's only novel foods. So which studies can you claim data protection for? So data protection will be granted by the European Commission as long as the following conditions are met. So the data needs to be newly developed scientific evidence or proprietary information that was designated by the applicant when the dossier was submitted. And also the initial applicant, so the first applicant, has the exclusive rights to use this information at the time that the dossier was submitted. Something that's really important is to understand that the data that you're claiming as to protect could not have been or could only have been used by EFSA to reach their opinion. So you can't just submit any old study. The study data was necessary, has to be necessary for EFSA to review and conclude on the safety of the novel food. It's also important that the studies must provide new data or evidence, and the data must be owned by the applicant as well. So you can't claim data protection for published studies, which is really important. And again, just to reiterate the first point, the study data must be relevant to the novel food assessment. So that means that EFSA needed access to this particular study or data to perform their safety evaluation. So moving on to some recent cases and recent precedents. So the first one is this partially defatted rapeseed powder. And this particular applicant requested data protection for a randomized double-blind controlled 4-week human study where they were testing the safety and tolerability in human consumers. But sadly, in this case, EFSA basically said that they could reach a conclusion on the safety without this data and without this study. So therefore, the Commission considered that the conditions for data protection were not met, and so they did not get data protection, which is a real shame because it would have been a huge investment for this company to actually perform that study, which in this instance was deemed not necessary by EFSA. But something to be aware of is that in this case, they could have requested other studies in addition to this human study for data protection. And I'll explain a bit more about that in my next slide. So in another recent case was the dried biomass of Euglena gracilis. And in this particular case, the applicant claimed data protection for 6 studies. So for one study, which was the in vitro, looking at in vitro fermentation, and then 5 studies that were used to support toxicology. And in this case, the Commission did ask the applicant to justify why they should protect the 90-day rat study, and to clarify if the applicant had the exclusive rights to these data. And the applicant was able to say that at the time of submission, they owned the data and they had the exclusive right to the study under the national law where this particular study was conducted. And therefore, the EC agreed with this argument and they granted data protection for all 6 studies. And I just wanted to show you what the novel food authorization looks like. So this is the microalga again. And on the left, you have the name of the authorized novel food. Then you have the conditions of use. So you have a clear list of the specified food categories that this ingredient can be used in and the maximum levels. Then you have specific labeling requirements, and finally the details on the data protection. So basically this authorization is protected until the 23rd of December 2025. And another very recent example is the dried yellow mealworm. And in this instance, the applicant requested data protection for very different studies. So in this case, it was the analysis of contaminants, the description of the drying process, so part of the manufacturing process, analytical data on the chitin levels, and also data relating to stability studies, and also allergenicity testing. This novel food has just been authorized, but we don't know the outcome of the data protection request yet because it's pending the implementing regulation. So it's going to be really interesting to see whether or not the European Commission has granted data protection for all of these studies. Also, I just wanted to highlight that confidentiality and data protection are 2 very different things. So confidentiality relates to the relevant parts of the dossier or data or studies that are not made publicly available, as doing so could damage the applicant's interests to a significant degree. Whereas data protection is where you protect specific data and studies, and this means that they cannot be used by another applicant for the benefit of their own dossier. So just to briefly cover all about this new transparency regulation and how it will affect confidentiality. So for those of you who are not aware about this new regulation, so we have in the EU a regulation on transparency that kicked in on the 27th of March this year. And this now means that the dossier and all supporting studies and data will be made publicly available, which is a big change. However, applicants can request to keep certain parts of the dossier confidential at dossier submission for all personal data. So that's given, that will always be kept confidential. The manufacturing process itself and technical and industrial specifications, the quantitative composition of the novel food, also starting substances and starting preparations that are involved in the manufacture of the product, information on the nature and composition of the novel food, and details on the analytical information and variability of the novel food and its stability. However, any information or data that is relevant to safety will not be kept confidential and will be made public. So in this table, I tried to summarize the data requirements for a novel food, for the novel food dossier itself, and then which studies you can claim data protection for and which studies you can claim confidentiality for. So in terms of the identity of the novel food, there's no way that you'll be able to claim data protection or confidentiality for this, because it's important for people to know what the product is. So you're not going to be able to keep anything hidden there. In terms of the production process, so and the manufacturing process, so you'll be able to claim confidentiality on this, but not data protection. In terms of compositional data, so this is the characterization of the novel food itself, purity data and stability data. So you'll be able to claim data protection for this when you're generating new information and new data, but you're not going to be, and the same for confidentiality, you can claim confidentiality, but if there's anything related to safety, so if there's any impurities that could potentially have a safety issue, then you wouldn't be able to claim confidentiality there. Same with the specifications. It will be very hard to claim confidentiality for anything that's relating to safety, but you may be able to claim data protection, particularly if you have developed a new method of analysis or it's a proprietary method of analysis. In terms of history of use, so the literature review that you use to support the novel food application, this you won't be able to claim data protection for or confidentiality. And the same with the proposed uses, use levels and intake assessment. That's all very important for people to understand what the novel food is. And also it has safety implications as well. So there's no way you'd be able to claim confidentiality there. Then moving on to the other sort of types of safety studies that support the novel food dossier. So the absorption, distribution, metabolism and excretion studies, and any nutritional and toxicological data on bioavailability. You're not going to be able to claim confidentiality for that, but you're likely to be able to claim data protection. Nutritional information, it will be very hard to claim data protection and confidentiality for that. And in terms of the toxicology studies and allergenicity studies, if it's your own data that you're generating for your own product and it's proprietary and it's new information, you'll be able to claim data protection, but not confidentiality, because these studies are relating to safety. And then finally, I just wanted to talk about animal feed, because a lot of alternative proteins could be used in animal feed. However, there's no novel feed regulation in the EU, and all alternative sources of protein are likely to be classified as feed materials. Feed materials are products of vegetable or animal origin whose principal purpose is to meet the animal's nutritional needs. And the thing with feed materials is that they don't require a full pre-market safety assessment and the full authorization procedure, as you do in the case of feed additives and novel foods. So the animal feed material route offers a really nice and easy way to market. However, it is the feed business operator, so the company that's placing the product on the market, that's legally responsible for ensuring that the products are safe and labeled correctly. But the real downside is that feed materials are generic. So once the feed material itself is on the approved list of feed materials, let's put it like that, then anyone, any other company meeting the specification can sell that product, can sell that feed, as long as they make sure that the product is safe and is labeled correctly. So it's really hard to protect your animal feed products, but maybe Kerry we can have a little discussion on that afterwards. So just to wrap up, basically, data protection can be requested for new scientific data and proprietary information. And this means that for your novel food authorization, the data that you're generating cannot be used by another company for the benefit of their own registration. To claim data protection, you must meet certain requirements, and the data protection is granted by the European Commission. As I've mentioned very briefly, beware of the transparency regulation. This has been a real game changer for applicants, meaning now that a lot of the information that you could keep confidential will no longer be confidential unless you request it. And the dossier, all the data, and even communication that you have with EFSA will be made publicly available from now on. And it is possible to request that certain data and studies be maintained or kept as confidential, but in this case, it will be EFSA making the decision on what will remain confidential and what will not, rather than the European Commission. And finally, just remember there's no data protection for animal feed ingredients, particularly for alternative proteins. So that's me done. So thank you all for listening. And again, feel free to email me if you have any questions. And I'm looking forward to the panel discussion now. And I hope there's lots of interesting questions for us to discuss.
That was great. Thanks, Hannah. That was super insightful. And I'm excited to get started with the panel discussion. And thanks everyone for pitching in the questions. We're looking at those now, of course, and I'm sure we're gonna cover most of them. Otherwise, feel free to reach out in an email. Hannah, perhaps if you could take off the shared screen, then we have a bit more space.
Sure.
And I was just thinking that maybe, of course, now we got insights from both sides, and both of you already touched upon, of course, in detail on what is data and why is that important, but perhaps just to debrief again in one line on both of your side, like how people should think of data when it comes to IP and when it comes to regulatory. What is the end goal?
Well, in terms of the data that you need for a novel food dossier, it's all relating to safety. The whole novel food dossier is related to safety, where Kerry's, I think, is slightly different.
Yeah.
Yeah, the patent, unless your invention is to do with safety or toxicology, like there was a problem with some safety feature, then not necessarily, it's not to do with safety, it's to do with making the invention plausible. So do you have enough information that the skilled person can repeat your invention? And do you solve the problem that you say you solve? Is there enough data in the application to make that plausible, that your invention solves that problem?
Great. Thanks, Kerry. I think we can already assign the elephant in the room, which is, of course, this whole new rule around transparency. And I think one of the core questions here is like a chicken and an egg problem, right? When to apply for an IP, when to apply for your regulatory approval, where to start, what to include, and I'm pretty sure we're not gonna find like a very specific fits everyone answer today. But I was thinking that maybe we could walk through on this process on a high level. Why starting with IP or regulatory, and when and how do they build on each other? And maybe we can even do it in an iterative way in this discussion. So, Kerry, would you like to go ahead?
Sure. I think
I'm pretty sure that when Hannah was telling about these the new transparency rule, I can imagine that with your IP mind, you were like, whoa, but if you publish all those, then you have to think of that ahead.
Well, that's it, because so as I said, that there's a strict novelty provisions. For example, you have to be, it's not for a patent application to be granted, your inventions must be novel, which means not disclosed, even disclosed by yourself. So so really the filing of the patent application should come first, I think, because the risk of a disclosure would prevent you from getting protection for your inventions. And presumably when you get to commercialization, so launching your product, before you get to that stage, you need to think about, are you infringing others' IP as well? So are there other third-party rights that you could be infringing before you get to the stage of having a product that you're ready to get the authorization for before you launch? So I think the IP comes first, and maybe the regulatory stuff is later, I think.
So,
Anna, what do you?
Yeah, no, I think so. I think that makes sense, definitely. Like logically, you have your idea, and if you want to protect it, you get your patent, and then from what I understand, you then have a year to tweak that patent, and then logically, it would make sense that once you have that, then in the background, you can start generating the data that you need to support your novel food application, which is very different to the data that you need to support the patent. So yeah, I think logically, it sounds like the patent comes first and then the novel food comes later.
Yeah, I agree. Yeah.
So when it comes to, as I hear, Kerry, you suggest starting with the patent, and then at some point when the company wants to go to market, then applying for regulatory. Are there some types of data that you generate in the regulatory process that could be a supplement in the IP application?
Yeah, so let's assume then that that data is generated later on in the process, so after the first year. So we're talking about post-filing data. So like I mentioned, you can't add data at that stage to the application. The data that you're going to draw upon at the later stage is to validate or back up, if you like, something that was plausible in your application. So in your patent application, you have to show that it's plausible and have enough information and data to get to that hurdle. And then if that's ever doubted, say, you can supplement that by referring to later filed data, but it will never become part of the application. It'll go on the public record, but it won't be part of the patent when it's granted. It'll be just used to base your arguments for inventive step before the patent office.
This is great. I'm thinking about timeline. Maybe just a refresh on that could be useful, Kerry, like how long processes take when it comes to IP and how long processes take when it comes to regulatory. Because I can see that it might be a risk that that you run out of time, and maybe you also at some point, I think it would be great to cover the 5-year data protection when it runs out on the regulatory side. How does that influence the IP aspect?
Mm-hmm.
Yeah, so let me just talk about typically a patent. You file your initial application, then there's a year that I talked about, the priority year, and you'll file a follow-on, which might be an international application, for example. But then it could take several years before you get to a patent being granted, if you ever get to that stage at all. But let's assume that you're successful. It could be, typically 3, 4, maybe 5 years down the line before you get your patent granted. There are ways of accelerating, but that's a typical kind of timeline.
Just thinking about that, so once you filed it, you filed your patent, then if you file your novel food application and then the things become public, would that invalidate or would that cause any issues with the patent being granted?
No, because the patent is judged, the date is judged as the filing date.
Ah, good.
Or your priority date. So if you've staked your claim and anything published before that date is relevant, but anything published after is not.
Oh, good. So we wouldn't have to wait then. We wouldn't have to wait the 7 years to get the patent before you file the novel food registration.
No, that one is not. So the patent is excluding others from making that product. Whereas I understand the regulatory side is you need that to launch your product.
Yeah. Yeah.
So it's two different kind of aspects, I think.
Yeah, no, absolutely. Even if you have a patent, you can't sell the food in the EU without it being authorized. So yeah, it's definitely completely separate. And in terms of timelines for the novel food, it takes probably about a year to generate all the data that you need to support the novel food dossier itself. And then, depending on the winds of EFSA and how favorable everyone is feeling towards your application, you're looking to probably a year to, 1.5 years to 3 years to get the actual authorization. So that includes the time for EFSA to evaluate the dossier through to getting the actual rubber stamp from the European Commission.
Okay, so you're mentioning this 1 to 1.5 year. Is that also the time when they're going to publish all the information publicly? Or my theory is how far you can delay your IP application if you would like to really keep it to the last minute.
So, I mean, there will be certain information that will be available publicly once you file even before you file the dossier. So now any communication that you have with EFSA pre-submission will be made publicly available. And so you need to be careful about what you're saying or what the information you're giving to EFSA. But then once the dossier is submitted, they have to do the whole confidentiality check, and they won't publish anything until the applicant has had a say about it. So, you know, you're saying I want to keep this part confidential, and if EFSA doesn't agree, they'll come back and say, you know, and you can have a conversation with EFSA until everyone's happy. So that whole process can take, you know, it can take a long time. We don't know timelines exactly yet because this is a brand new process. So we're still not 100% sure how it's all going to work. Oh,
you're on mute, Gaza.
Okay, so telepathy still doesn't work, but thanks. Perhaps we could shift gears. We're very limited on time, but maybe we can touch a few more topics just real quick. So one of the topics we discussed is also when preparing for this webinar is in regulatory, you would like to protect or cover like full products, right? And in your IP application, it's more about protecting specific aspect, processes, technologies, ingredients. Where are the overlaps here? What are the limitations?
The food is, you can have patents to the food as well. So, well, I doubt you would anymore because it's not novel anymore. But making a cultured meat product, if that were novel, you could protect the meat, the actual steak or whatever that you would sell. So you would try and protect the actual thing that you're selling. But you can protect other things as well, like the method used to make it, any tweaks to the method. So, and patents don't have to be these mind-blowing kind of groundbreaking achievements. They can just be small increments that are just not obvious or have an increased, I don't know, yield or something like that. Some technical effect that isn't obvious.
It actually, we just received a question from Jonathan that's pretty relevant, asking you, Kerry, that if you see any specific ways companies like to protect their cellular agricultural products, ingredients, technologies, if you already see a pattern or it's perhaps so new that it's hard to assess.
There are different players, I think, in the cell ag market. So some that make bioreactors, some that are more concerned with the culture media, some are stem cell providers, and they protect those aspects. So I don't think there's a company that protects all of those. It's along the chain of manufacture, and each are protecting their own kind of bit. But you will, you know, if you're a bioreactor manufacturer, you will try and protect that because that's the core product, but you'll try and protect downstream things like a method of using it or a meat product produced by that, using that bioreactor. Because you're trying to attract licenses, aren't you? You're trying to get people interested, to get people kind of covered by your patent, so then they'll have to take a license from you potentially to act as a source of revenue. So you're trying to protect all different kinds of things, but you protect your core invention is the primary goal.
And it's interesting because when if you happen to create, like, let's say, a cultured meat product, you will need to protect those aspects, but in the end you will need to prove that the full product is safe to consume, right, Hannah?
Yeah, absolutely. Yeah, you might have an incredible, I don't know, well, take cell ag, for example. You know, a lot of the cells will need to be modified, genetically modified in some way in order to differentiate. And that could cause issues from a regulatory perspective, particularly in the EU, because then it would be classified as a GM food. So you may be able to patent your wonderful cells that do all of these incredible things, but you may face regulatory hurdles because of the modification techniques that you've used.
Great. We unfortunately running out of time soon. I think we have lots of great questions here. Perhaps if you think, Hannah or Kerry, we can also just pick a few of them to answer if you would like.
Sure. Yeah.
And then with the rest, we can maybe get back in the follow-up email, just so people know in the audience. So please feel free to pick a few last questions if you think it makes sense.
I think the one that's really interesting is, you know, that if you get data protection and you have the data protection for the 5 years, what happens after those 5 years? I think it's a question from Ezil. So yeah, if the data studies are covered by confidentiality and data protection, how will others have access to it? And is the data protection applicable post the 5 years? And from the novel food regulation perspective, no. So once the data protection has expired, so once the 5 years has expired, then any other company can use, well, the authorization becomes generic essentially, and anyone can sell the same product. But maybe if you have a patent then in place, then you're protected. I don't know, Kerry, is that?
Yeah, I think so. So I think there are a couple of questions along those lines. So I understand that now things are going to be more public, aren't they? They're not going to be, you can't rely on the confidentiality anymore. Mm-hmm. So things like, there's a question from Catalin, I think, I'm sorry if I mispronounced your name, about because of that, should you get more use patents? Then potentially yes, because you might not be able to rely on the data being confidential. So you might want to try and get protection via the patent system. And you certainly can have use claims. So a use of I don't know, an enzyme or an ingredient in a method, those kind of claims. And there's another question by Kai, I think, about public disclosure in the regulatory process that companies might wish to patent. Yes, because, but you need to file your patent application before there's any publication of any of that information.
Yeah.
There's a great one there as well. I think it's pretty relevant for these times. How will UK novel food approvals differ from EFSA?
So at the moment, the UK FSA is following the EU regulation. So basically your novel food dossier that you submit to EFSA is valid for the UK. And the other good thing is that the UK hasn't applied the transparency regulation. So you don't have to go through all of the hassle of the confidentiality. You know, they're not going to be making the dossier itself public. So in terms of the process, they're following the EU food law and food legislation and EFSA guidance documents, but they're not following the transparency regulation.
Yeah, that's great. Here's a question, the last question from from Sridevi. What are the pros and cons of the new transparency regulation? Any comments? I was thinking we could perhaps reframe this in a different way. And what are the pros when it comes, like, you know, how to embrace this as a company when it comes to the pros. What do you get out? And then perhaps instead of the cons, maybe Kerry, you could reflect on how to work around the cons and how to be more proactive with your IP strategy, kind of how to compensate that, if that makes sense.
Yeah, sure.
Hannah, if you would like to start.
Yeah, so I mean, the whole reason the transparency regulation came about is because of consumer pressure and consumer concerns about glyphosate and the reauthorization of glyphosate and all of the safety studies that were used to support the reauthorization of glyphosate. So the EC decided to launch this whole, you know, investigation into transparency and to, you know, it's a big citizen initiative. So it's basically there to protect the consumer and to give the consumer extra confidence that that the studies that are being used to support all products in the food chain, so not just novel foods, but feed additives, pesticides, plant protection products, that everything that's being put in the food chain is safe. So it's really to give customers more confidence in the food chain itself. So that's sort of the history behind it. In terms of benefits as well for clients, so it means that the whole process is much more defined. So the application process is more defined. You can have pre-submission meetings with EFSA now, which we've never been able to have. So that's a benefit. So you can discuss your strategy with them and say, you know, I'm proposing that we perform these studies. Do you agree? So that's something we've never had before. And also they have produced templates. So it's all electronic submission of the dossier now following set templates. So it makes things much easier. But apart from that, I can't think of any other massive benefits. It's pretty much a headache, and it's introduced a lot of extra bureaucracy. Yeah, and the whole confidentiality thing is tricky, but we can't do anything about the law.
No. So I think I've said it before, that basically I think because things are maybe not going to be confidential and publicly disclosed, then there might be a greater need for filing patent applications to cover the data that you thought would otherwise be confidential anyway. But obviously, we haven't really talked about freedom to operate and infringement risk. I've talked about obtaining a patent application, but there needs, you know, you really should review third-party IP before you go to the trouble of applying for data regulation and kind of regulatory approval if you come to launch a product and then find you're infringing somebody else's patent anyway. So getting your own patent is only one side of the, you know, side of the story. Is how are you infringing others as well, and that needs to be managed before you launch a product.
There's a lot to do. It sounds like that.
Yeah, it's not
Great.
Straightforward. It's not straightforward.
No. Great. I think we are getting to an end for today. Is there anything else on the two of your side we should cover?
I mean, there's quite a few questions that we haven't managed to answer, but I'm happy to follow up with everyone afterwards, and I'm sure there's a way that we can send all of the questions to the participants.
Absolutely, yeah. And I'll answer the IP relevant ones, and if there are any questions, I think the slides are going to be shared, aren't they? So yeah. Our contact details are on there, and if anyone wants to get in touch, then please do.
Yeah, great. Thank you so much for the two of you to be willing to be on the stage and sharing all these insights. I think it was very, very insightful, and also a very unique event. I at least haven't been attending to any of the webinars these days where they covered both aspects. So we hope that all of you in the audience find this valuable. And as Kerry and Hannah already mentioned, we will follow up in an email with all the answers to these questions, also with the recordings, the video recordings, and I believe also with the slides. So you will have it in all places. And I believe you know Hannah's and Kerry's and my contacts, so please feel free to reach out. We are one email away, and we hope to see you soon, maybe to another webinar. All right. Thanks, everyone.